Hello everyone, I'm Mathur and I'm a legal intern at LEXIS and Company. I'm really honored to have this opportunity to intern with LEXIS and Company, which has given me this chance to present this video in front of you all. So the topic or purpose of my today's video is to discuss about vicarious liability, which is a topic of law of torts. So let us start. Generally, a person is liable for his own wrongful acts and one does not incur any liability for the acts done by other. In certain cases, however, vicarious liability, that is a liability of one person for the acts done by another person, may arise. In order that the liability of act A for the act done by B can arise, it is necessary that there should be a certain kind of relationship between A and B, and the wrongful act should be in a certain way connected with that particular relationship. Now, the common examples of such kind of vicarious liabilities are the liability of principal for the tort of his agent, liability of a partner for each other's torts, liability of a master for the tort of his servant. So, vicarious liability deals with the cases when one person is liable for the acts of others. In the field of torts, it is considered to be an exception to the general rule that a person is liable for his own acts only. It is based on the principle of qui facet per se per alium facet per se, which means he who does an act through another is deemed in law to do it himself. So in a case of vicarious liability, both the person at whose behest the act is done as well as the person who does the act are liable. Thus, the employers are vicariously liable for the torts of their employees that are committed during the course of employment. Now, what are the reasons for vicarious liability to arise? There are several reasons which are advanced as a justification for imposition of vicarious liability. First is that the master has the deepest pocket, which is the wealth of a defendant, or the fact that he has access to resources via insurance, has in some cases had an unconscious influence on the development of legal principles. Second is the vicarious liability encourages accident prevention by giving an employer a financial interest in encouraging his employees to take care for the safety of others. As the employer makes a profit from the activities of his employees, he should also bear any losses that those activities cause. Now, what are the constituents of vicarious liability? First, that there must be a relation of certain kinds between the master and the whoever has the tort, committed the tort. Then the wrongful act must be related to that particular relationship in a certain way, and then the wrong which has been committed should be committed within the course of employment. Now, now there are two different factors in vicarious liability. That is a factor related to, for example, of servant, and one is for the independent contractor. Let us discuss both of them. A servant and an independent contractor are both employed to do some work of the employer, but there is a difference in the legal relationship which the employer has with both of them. A servant is engaged under a contract of services, whereas an independent contractor is engaged under a contract of services. Now, the liability of the employer for the wrongs committed by his servant is more onerous than his liability in the respect of wrongs committed by an independent contractor. If a servant does a wrongful act in the course of his employment, the master is liable for it. The servant, of course, is also liable. The wrongful act of a servant is deemed to be the act of the master as well. The doctrine of liability of the master for act of his servant is based on the maxim respondeat superior, which means let the principal be liable, and it puts the master in the same position as if he had done the act himself. It also derives validity from the maxim qui facet per alium facet per se, which also means that he who does the act through another is deemed in law to do it himself. Since for the wrong done by the servant, the master can also be made liable vicariously. The plaintiff has a choice to bring the action against either or both of them. Their liability is joint and several, as well as they are considered to be joint tortfeasors. So the reason of the maxim respondeat superior seems to be for better position of the master to meet the seems because of the better position of master to meet the claim because of his larger pockets and also ability to pass on the burden of liability through insurance. The liability even though the servant acted against the express instructions and for no benefit of his master. For the liability of the master to arise, the following two essentials are to be present. That is, the tort was committed by the servant and the servant committed the tort in the course of employment. A servant is a person employed by another to do work under the direction and control of his master. As a general rule, the master is made liable for the tort of his servant, but he is not made liable for tort of an independent contractor. It therefore becomes essential to distinguish between the two. A servant is an agent who is subject to control and supervision of his employer regarding the manner in which he wants the work to be done. An independent contractor is not subject to any such control. He undertakes to do certain work regarding the manner in which the work is to be done according to him. He is his own master and exercises his own discretion. An independent contractor is one who undertakes to produce a given result, but so that in the actual execution of the work, he is not under any order or control of the person for whom he does it, and they use his own discretion in things not specified before it. For example, my car driver is my servant. If he negligently knocks X, I will be liable for that. But if we hire a taxi for going to railway station and the taxi driver negligently hits X, I will not be liable towards X because the driver is not my servant but only an independent contractor. So the taxi driver alone will be liable for that. So that's it for today. Thank you everyone. Have a nice day.